The Railway Labor Act, or RLA, became law in 1926 to resolve labor disputes between employees and railroads. In 1936, Congress amended the RLA to include airlines. The RLA is designed to minimize disruptions to the national transportation system by having a formal process to resolve disputes and negotiations. The RLA's basic purposes include avoiding interruption to commerce, ensuring employees have the right to join a labor union, assisting in the settlement of disputes over rates of pay, work rules, or working conditions in contract negotiations, assisting in settling disputes over grievances or the interpretation of existing contracts. Airline contract negotiations are governed by Section 6 of the RLA, which outlines the legal process for negotiating changes to collective bargaining agreements. The Section 6 process begins when the union and company exchange proposed changes to the contract, often referred to as contract openers. Unlike other industries, a contract under the RLA doesn't expire, but has an amendable date. This means that the existing contract stays in place until both parties agree on a new contract. While direct negotiations are underway, each side must maintain the status quo. Management cannot lock out employees or impose new contract terms, and unions cannot engage in self-help, such as strikes, slowdowns, or other job actions. At any time during direct negotiations, if either or both parties feel that negotiations are not progressing, they can file for mediation services with the National Mediation Board, or NMB.